Heyo! Welcome, welcome to Jodi Day. And as you might see, Dave's not here. It's like a Cheech and Chong sketch. Hey, it's Dave. Dave? Yes, it's Dave. Dave's not here. No, it's Dave. Dave? Dave's not here. But instead of Dave, we have Legally Live, McKinley.
Hi.
Hi.
How are you?
I am doing good. And how are you doing?
I am doing great. Great.
Thank
Just got
you.
back from court.
Oh, how did it go?
Oh, so wonderful.
Yeah, you seem overjoyed.
Yeah. It was super worthless.
Yeah, that's most days or just most days.
Yep.
I mean, people think our line of work is very, very interesting. I can tell you, 95% it's shuffling papers.
Mm-hmm. Yeah, today I should not have had to go in today because all it was me telling the prosecutor that the case was going to get set for trial if they didn't change their offer. And this is like the 50th time I've told her. So,
Yeah, but the prosecution has this that it's not their money they're spending.
Right.
It's the taxpayers' money, and they as
And
with
they don't care.
yeah, it's like politicians. It's not my money. I can sit here and wait until you take a plea, so I can declare a win. Another point in my statistics.
Yep.
Okay. Dave is in our chat, even though he has his own trial. Hi, Dave. So everybody, go over to my channel. Give me all the likes and all the stuff. And yeah. But
okay.
yeah, have you?
Hello? What happened?
Yeah, I can hear you.
No. Oh. Hold on.
Technical issues.
Can you hear me? So you didn't really go out? Yeah. It's because I have this little thing, and I did not realize when you open the top of it, it shuts off your other device.
Oh.
Who knew?
Yeah.
Okay, I apologize.
No worries. I'm not that technical. I have my $30 webcam. I got my new PC, and I have this amazing source of lighting, which is more or less
nice.
Yeah, light bulb, and yeah, keeping it simple. But I do invested in good sound, so that's so people can hear, because the important thing is the trial and commentary, because this is a trial commentary channel.
This is true.
Yeah. We left off during the cross-examination of the Jodis psychologist who testifies that, she has amnesia because PTSD, because this and that, and she's been sitting there smiling because this guy, who apparently is a certified sex therapist as well, and in the state where he also worked, another state, if it was New York State or something, he had to sign a document where he agreed to that getting involved with your clients is not a good thing. So, yeah.
Did he get involved with his client?
It appears like he wasn't, reprimanded. He just had to sign the letter and go a training course about not getting involved personally with your clients. And that with sex therapist thing, and then, yeah. And, yeah. But when you see sex therapist, is this the guy, if you would ever consider going to sex therapy, is this the guy you would go to?
Probably not. Probably not.
Yeah.
Nope.
Yep.
Nope.
Now we have about 10 minutes left of day 32, and then we go directly into day 33. We didn't yet. Yeah. And Dave said if and when they go to lunch, he will send all the people over and join. But
okay.
They started late, and this judge is more punctual than the judge in my trial, the Young Thug trial. Today he was 45 minutes. Today he was 45 minutes late, but he still he does that. I haven't seen a day of court where he isn't at least 20 minutes late.
Yeah,
and then
I used to watch it. He's always late.
Yeah, and then it takes his 15 minutes break are often 25 minutes, and his 1 hour lunch break is an hour and a half.
Mm-hmm.
Yeah, it's infuriating because it's a waste of the jury's time. Because
but the whole case is a waste of their time.
yeah, but he constantly yells at the defense about don't take up, don't waste the court's time. And then, yeah.
And then he's the king of wasting the court's time.
Yeah. But we are not here for the Young Thug trial or the Cromley trial. We are here for the Jodi trial. And as per usual, me and Dave are dual streaming. So in my chat, Dave's stream is linked in the top of the chat. And over at Dave's place, my stream is pinned on the top of his chat.
How can he can stream 2 different things at a time?
Oh yeah, I have the admin thing on his StreamYard.
Oh, okay.
So I can set everything up for him.
Oh.
So I'm streaming through his StreamYard or something like that. It's technical stuff.
Okay. I'll just trust you.
Yeah. But yeah, we are in the middle of the cross-examination. And remember, folks, give me all the likes. And it's a friendly competition between me and Dave, who gets the most super chats and gifted memberships. And since he's not here, give it to me. And go subscribe to Legally Live.
Yes.
If mods on both channels can please put the link in. Yes, we know, Sal. Don't hit end stream. Apparently, that's not how you exit the studio.
Oh, yeah, I know.
We know, Sal. We know that. We also know that you have to press the wrong button twice to actually end the stream.
Oh.
Okay, but yeah.
Okay.
Final 10 minutes of day 32, and then we will move on to day 33.
Right?
Could you repeat that?
After this was administered, this test 533.
Yes.
There was a subsequent meeting, right?
Afterwards, yes.
Yes. And during this subsequent meeting is when the story changed, correct?
Correct.
And during that story change, one of the things that the defendant told you was that this story about the strangers was fiction, correct?
That's correct.
And that, in fact, she had been the one to actually kill Mr. Alexander, correct?
Yes.
And this wasn't the first, for you who are completely new, this wasn't the first time her story changed. First, she was never there. Then it was ninjas or masked assailants. And now she changed it again to self-defense.
Yet you did not administer another PDS, correct?
That was an oversight, and I should have done that.
And, sir, one of the other things is that during this conversation, or during your meetings with the defendant, you and she talked about a number of things, didn't you?
Well, sure.
In fact, one of the things that you talked to us about during direct examination was the specifically the rope at the crime scene. Do you remember answering questions about that?
Yes,
Isn't it true, sir, that one of the things that the defendant told you about that rope was that she was tied at the hands, right?
yes.
And she also told you that she was tied at the ankles. Didn't she tell you that?
Well, that's what I had in my notes.
No, I'm not asking you what you had in your notes. I'm asking you whether or not that's what she told you.
I don't remember what she told me.
Well, you have notes though, right?
But I do have notes.
And those notes are made at exactly the time that she is relating that to you, correct?
That's correct.
And those notes reflect on 2 occasions.
Okay, I discovered that since Dave is streaming on Twitter, this stream will not go to Dave's Twitter. So that I can't dual stream on his channel.
Ah.
Yeah, but it's not my fault, so...
No.
On 2 separate parts that she was tied down at the hands and the ankles, right?
That's what my notes reflect, yes.
And there's no reason for us to doubt your notes, right?
No, there aren't. The
Because-
one thing, the fact is that most of the time over the years when people have said they've used rope, they tie the hands and the ankles. It is conceivable that in my attempt to write down quickly as she's talking, I may have added that by mistake, but I don't.
That was a stupid thing to say in court. I mean, listen here, Yuri. Here I am trying to make myself as believable as possible. I might be bad with notes.
Is she testifying for the defense? I mean, is he testifying for the defense?
Yeah, yes, this is cross-examination, but he is a defense witness.
Okay.
But in his report, he mistakenly left out that he put down tied with hands and ankles. And now in his notes that he had to provide to the state, oh, didn't you write ankles too? Well, I might have done that by mistake. Sir, no.
That's weird.
Yeah.
Remember, so you have to go with what I wrote.
So are you confessing or saying that you were wrong in writing that down?
I don't know.
So, but isn't that the notes, isn't that what forms partly? Isn't that part of the clinical interview?
Yes, it is.
And isn't that part of what has formed your conclusion that she was afflicted with post-traumatic stress disorder?
Yes.
And so don't you think that would be important to make sure that you were accurate?
The formulation of the post-traumatic stress disorder came about after a careful analysis of the notes, the crime scene material, and her changed story. These tests, which I had administered earlier, did confirm the presence of post-traumatic stress disorder, although I was in error by not re-administering the PDS.
And I'm not talking about those tests. We'll talk about that probably tomorrow, but I'm talking about the statement to you from her that she was tied both at the hands and also at the ankles.
Yes, well, that's what I wrote.
And there's no reason as we sit here today to doubt that, right?
No.
And one of the other things that she told you was that even though when this was going on and she was tied down, that it was actually Mr. Alexander, when this was happening, that he actually cut the ropes as he approached climax, correct?
Yes.
And he used a knife to cut the ropes, right?
Yes.
And then as he approached climax, she straddled him or got on top of him, right?
Yes.
And while she was on top of him, that's when Mr. Alexander took the photographs, the nude photographs,
That's
right?
correct, yes.
Okay. I want you to take a look at exhibits 164, 165,
Yeah.
168, and 169.
Those are the pictures that the trial stream accidentally showed on day 6, I believe. The videotech videotech was supposed to cut video and only have audio, and he switched the wrong button, so it was all video, no audio. So all of Jodi displayed for the world. All the holes.
Ew.
purpose of those pictures was to prove that she was there the day she originally claimed she wasn't there.
Yeah.
That she's a lying liar who lies.
Mhm.
Okay,
Those are photographs of Miss Arias, correct?
yes,
And those are the photographs of her sprawled or laying back on the bed, correct?
yes,
It also shows a picture of her vaginal area, correct?
yes,
And it also shows a picture of her backside, right?
yes.
In none of those pictures,
Court reporter.
that Mr. Alexander appears in none of those pictures, correct?
Correct.
Those are the pictures, sir, that were, well, did you ever see or look at these pictures after you talked to Miss Arias and you received the story about the pictures being taken while she was straddling him?
I saw some pictures, but I don't believe I've seen all of them.
So don't you think it would have been important to look at those photographs so that you could see if you could corroborate what she was telling you at that time? What's happening?
Actually, I had the photographs when I first began the case. It would have been helpful to corroborate, yes.
And that wasn't done in this case,
No.
correct? And if you would have looked at those, that would have provided you an opportunity to ask her about this particular issue, right?
Yes,
Since that's part of what goes into this post-traumatic stress disorder diagnosis, looking at what somebody tells you and whether or not it can be corroborated, right?
well, I didn't see a major contribution to her post-traumatic stress disorder as a function of the sexual life that they were having.
But if somebody is a liar over and over with something like that, don't you think that that's something you would consider?
Objection is a characterization as someone being a liar. That's certainly not what Dr. Stangus would agree to.
Approach, please.
And the sidebar. Let's skip ahead a bit. Or we can do like we did on Saturday. If you want me to skip minutes, you know what to do. $10 gives you 10 minutes. $2 gives you 2 minutes. $5 gives you 5 minutes. But that was during direct examination, and that was extremely boring. So,
Hypothetically speaking, isn't it important if you have someone who you are assessing, if they lie to you over and over again, isn't it important to corroborate things?
I didn't view the story she was telling as a lie.
No, I'm not asking you about this case. I'm asking generally speaking, sir.
The information that I get in a case can be corroborated to some degree.
No, but my question, sir, is if someone, not this case, generally speaking, in your experience, all these years that you've had, if someone is constantly lying to you, not this case, if someone is constantly lying to you, don't you think it's important to attempt to corroborate what they're telling you?
If I knew someone was constantly
Yes.
lying to me, I would discontinue the evaluation because it wouldn't be worthwhile continuing it.
So you wouldn't corroborate, you would just discontinue it then, right?
If I knew somebody was lying consistently, what would be the point of me to continue either with therapy or with an evaluation?
What if they only lied 3 or 4 times that you knew of? Did that make a
If I
difference?
was able to corroborate that, of course I would.
With regard to these photographs, our information, or you can see on there the date and the time.
Right.
Give me a date.
6408,
At what time? Give us a time.
1:42 p.m.
At that time, sir, according to your assessment, she was not suffering any of these foggy memories then, was she?
To my knowledge, that's true.
Oh, no, you're the one that told us when she was. Do you remember you did the graph?
The foggy memory occurred at the time of the killing.
Right. So at that point, she was not having any memory problems, right?
Correct.
And she wasn't foggy, right?
Correct.
So that if that's an inconsistency, it cannot be attributed to her having a foggy memory, correct?
That's true.
I don't have anything else to say. Well, I mean, pursuant to what we talked about, I don't have anything else to say.
All right. Objection is overruled. The answer will stand. Ladies and gentlemen, we're going to take the evening recess. Please be back in the designated area. Can everyone be here at 10 o'clock tomorrow morning? 10 o'clock? Have a nice evening. You are excused. Please remember the admonition.
all right, that was day 32 in the done. And remember, Vielhammer Media is the YouTuber who made this audio enhancement video. So it's thanks to
record will show the jury has left the courtroom. We are in recess. Dr. Samuels, you may step down.
Thank you.
Yeah, Vielhammer Media. That is the account you need to subscribe to for. He magically takes horrible court audio and makes it bearable, and he takes bearable audio and makes it crisp. And I don't know how he does it. He's one of these magicians who does something with the audio to enhance it. So if you have the chance, thank him by giving him a subscription. But
Yes.
now let's go to day 33.
Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Good morning, ladies and gentlemen. As always, thank you for your continued patience. Mr. Martinez, you may continue.
Sir, as part of your evaluation of the defendant, one of the things that we talked about yesterday was a clinical interview, correct?
Yes,
And the clinical interview is nothing more than you sitting there and talking to the defendant about a variety of topics that may be appropriate, correct?
well, a mental status is conducted, and a history is
Is that
conducted.
yes or no?
I can't answer that as a yes or no.
So you don't sit there and you talk to the defendant during these clinical interviews?
Yes, we talk, sure.
And there are issues that are discussed during these clinical interviews, correct?
Yes,
And basically what happens is you're sitting across a table taking notes while she addresses whatever issue is relevant at that point, correct?
yes,
And in this particular case, one of the issues that you addressed was whether or not she had had anal intercourse with Mr. Alexander, correct?
yes,
And in fact, one of the things that she told you was that he was the only individual ever that she had ever had anal intercourse with, correct?
early on in our discussion, she did say that.
Well, you're implying that later on in the discussion, she told you something different. Isn't it true that that is how it was left? She said, he is the only person that I've ever had anal intercourse with, right?
Yes,
Additionally, one of the things that we've heard was that, and you discussed other aspects of the sexual interaction between her and Mr. Alexander, correct?
yes,
And in fact, one of the interactions that you discussed with her was the first interaction where they had oral sex, correct?
yes,
And she also may have indicated to you that she was uncomfortable about that, correct?
yes,
But isn't it true, sir, that she has had up to that point, an extensive experience in oral sex?
she had told me she experienced it before that, yes.
And in fact, it started when she was, at least she told you, it started when she was at the age of 15, correct?
Objection, relevant.
Of oral.
Yes,
And in fact, she was the one that initiated this oral sex with an individual by the name of Clinton, right?
I don't know if she initiated or not, but she did engage in it with him.
With an individual by the name of Clinton, correct?
Yes,
And so it isn't a situation that she was uncomfortable because it was a first time kind of thing with Mr. Alexander, was it?
no, that wasn't it at all.
The other thing that you discussed with her was the computer and what was on the computer. Do you remember talking to her about that?
Whose computer?
Mr. Alexander's computer.
Okay, yes,
And one of the things that you indicated to me was that she told you that that computer had many, many pictures of women's breasts.
yes,
And that's information you received from the defendant, correct?
yes.
Do you know whether or not you checked? Do you know who somebody by the name of Lonnie Dworkin is?
No,
Do you know whether or not that computer was ever checked out to see whether or not it had any pictures whatsoever of
well, I'm
breasts?
sure that it was.
Pardon?
Well, I'm sure that it was, but pictures of breasts are not illegal.
I'm not saying that they're illegal. We're not talking about that. You understand that? We're talking about the fact that she told you that there were many photographs of women's breasts on Mr. Alexander's
Yes.
computer, right?
Yes,
And what if it turned out that there were no pictures of women's breasts on Mr. Alexander's computer? Would that give you pause in your...
Yep. With Mr. Alexander's computer now, Jodi has claimed a lot of things about Mr. Alexander, of him being attracted in the wrong way, or there's no right way, to young boys, and all of that. Here's the thing. There was no time for Mr. Alexander to clean up his computer or clean up his phone or clean up his laptop. He was murdered. The cops looked through his phone, looked through his computers, nothing.
She probably cleaned it up for him because, she's polite.
Yeah, exactly, because... oh, yeah. it's not going too well for Miss Aries, but I think at this point she still believes she's winning this trial. Just like some other slightly histrionic whatevers that we saw a couple of years ago. Me and Dave, we say that Jodi Arias is the original Amber Heard.
Oh, yeah.
And I know we have audience who believe Amber. That's your opinion.
What? I'm kidding.
Yeah. That's your opinion. Perfectly allowed. I have explained in several streams why I believe Amber Heard. And I use the example of the severely sliced feet. And I do labor law. I see injuries too often. And somebody who has injured feet, sliced feet, you need medical attention, because anything that happens to the soles of your feet will get infected. The soles of your feet are so dirty, especially if you're claiming to have been walking around barefoot the days after. I mean, you need stitches, you need band-aids, you need medical attention, and it's simply physically impossible the way Amber Heard described that situation.
Oh, yeah. The walking on glass and stuff?
Yeah, the dragging through glass and stepping on glass and severely sliced feet. It is literally impossible. Literally, as in how the word is supposed to be used. No, C-Sweat, the one who believes Amber is not Sadie, at least not what I know. But I would assume that she took pointers from her as well. But this is not the Amber trial, this is the Jodi trial. So let's continue watching this gentleman not proving Jodi's case for her.
Or evaluation in this case of the defendant?
I didn't see it as relevant.
You talked about it, but you don't see it. That's not important, right?
No, it's not important.
So it's not important to you that the defendant may have lied to you during the clinical interview.
Objection to the characterization of lying. There's no information that is even a lie or untruthful in any way.
Approach, please.
Oh, she's short. Or it looks like she's short.
Who?
Well, actually, she's not. The defense attorney. Well, maybe they're both just short. The man and the woman.
Oh, Mr. Mendes is 5'7".
Oh, really?
Yeah. We checked up everybody's heights because it's funny, because Dave is 5'7" and he claims he's not short.
That's funny. I mean, that's very tall to me, but
yeah,
you know.
yeah. I'm almost 2 full feet taller than you.
Yes.
Yeah.
May continue.
With regard to this particular computer, assuming that there were no images of women's breasts on it, and you had been told by the defendant that there were, would that give you pause in the evaluation?
There are many possibilities why those images were not on the computer.
I'm not asking you about that. I'm asking you, you're not a computer expert, are you?
No, I'm not.
You have testified to a number of things, but that's one thing that you are not, right?
Absolutely.
And so when you're trying to tell us why there may or may not be many reasons why an image may be or may not be in a computer, you don't have any reason to know what it may be, right?
I saw that as irrelevant to the case.
I understand that you saw it as irrelevant. I'm not asking you about that. I'm asking you, my question is this. You indicated to me that the defendant told you that there was on the computer images of women's breasts, lots of them, right?
Yes.
If I say to you, what if it turns out that there are no images of women's breasts on the computer? You can see that there's an inconsistency there, right?
There's no objection to this one.
Right?
Yes, there's an inconsistency.
Right. And if there is an inconsistency with regard to this, and for example, other issues, does that not give you pause while you're conducting an interview, since there are these inconsistencies?
There are certain inconsistencies that are irrelevant to the case.
And so the answer is no, even though these inconsistencies.
I'm still amazed that the defense attorney, he has a lot of options in clothing, and he chooses that high.
Why? What's on his tie?
I think it's a dolphin tie.
Weird.
Yeah. But there are worse examples of, yeah. But I try to not judge, but for me, when I have to do the dress up, I have my 3 suits. I have my black, my dark blue, and I have my beige, or whatever you call it.
Mm-hmm.
And then I have 5 different shirts to that, and then I have 5 different ties, so I can change around, but everything in darker colors.
That seems like a good plan.
Yeah, and he sometimes wear a pink shirt with an orange tie, or vice versa, and
Not a snazzy dresser.
no, I don't think he is married, and he might be, I don't know. I would assume a wife who looks at him in the morning when he puts his clothes on. No, honey, that doesn't fit.
Don't wear that.
Psychologist, red tie, pink shirt, yeah. But welcome to the mid-noughts. This is from 2013, so it's 11 years ago. More or less to the day 11 years ago.
Since these are there, you're saying it doesn't matter to me in my evaluation. That's what you're saying, right?
It was not germane to the issue I was investigating.
Right. In other words, you're saying it doesn't matter to you that there were these inconsistencies in this case.
Could you repeat your question?
It doesn't matter to you that there are these inconsistencies in this case as they apply to the defendant.
Those particular inconsistencies did not affect my opinion.
I'm not asking you if they affected your opinion. I'm asking you whether or not inconsistencies such as these would give you pause to at least look at what's going on a little deeper in this case.
Objection, because that is a question and he's already answered it.
Yes, some inconsistencies that were significant to the case, I did investigate further. Those I did not.
But other issues that you deemed, and it's your call, what you're saying right now is, I can look at something and if I consider it irrelevant, generally speaking, they can lie to me because it's not important.
I did not assume that it was a lie.
No, that's not what I'm asking. My hypothetical to you is, generally speaking, not this case, generally speaking, if an individual lies to you about something that you consider irrelevant, then it's no harm, no foul, right?
It depends upon what the issue was related to.
Well, no,
obviously, if it's important to the case and the aspects of the case that I'm studying, I will certainly investigate further. But the fact that whether or not they were pictures of breasts on the computer.
I'm not asking you about that.
You're not letting me finish.
The judge is not responsible.
Objection sustained. Finish your response.
Thank you. The presence or absence of breasts on the computer was not of concern to me because there are many possibilities with my limited knowledge of computers that could account for that. And therefore, since pictures of breasts are legal and it did not come up anywhere else in the case, I did not see the need to pursue it any further.
Are you done with your answer?
I'm not completed with my answer.
Sir, my question was something else. Hypothetically speaking, in a situation where there's something that, as you've just told us now, is irrelevant, you've told us that, in a situation where an individual is involved in a clinical interview like this, and there's an irrelevant issue as you've deemed it, and you find out later that irrelevant issue, this individual lied to you about that, that still doesn't give you pause at all.
I did not consider it lying. There was a discrepancy between what was on the
Judge, he's not being
computer.
responsive to my question.
Okay.
You need,
Listen carefully to the question. Repeat your
Could
question.
you repeat your question?
sure. Generally speaking, not in this case, if an individual in a case involving something that you say is irrelevant, you've already deemed that it's irrelevant, lies to you about that irrelevant aspect, what you are telling us is that it doesn't matter to you because you've deemed that it's irrelevant.
It's a piece of information, but not to my evaluation, an important piece of information. Obviously, if someone lied to a pertinent and important fact in the evaluation, it would be investigated and it would strike a bell, and I would be far more concerned about it than something which I did not see as being relevant to the issues under study.
So generally speaking, a person, when you're conducting these evaluations, they could lie to you about 10, 15, 20, 30, 50 things that you consider irrelevant. And that's part of the hypothetical that you consider irrelevant. That still would not affect your opinion in the case, correct?
If they were 50, If they were 50 or 60 points, yes, of course it would raise an alarm to me. But I did not see more than this one.
Sir, you didn't see more than this one in this case?
Well, other than the issues that were under control, that were under investigation, which were very important.
So other than this issue involving the breast, you didn't see any other inconsistencies in this case? Is that what you just said?
There were inconsistencies in the case.
Yes or no?
I can't answer that.
Yeah, the prosecutor has already made his point, and then he goes on and on and on and on and on and on, and it's
unnecessary.
Yeah, exactly. It's not necessary. He already made the point. Then he can move on. Instead of, this trial lasted for, I believe, 58 days. This trial should have been a 2-week trial.
Yeah.
Yeah.
Right.
Most murder cases in the United States are less than a week.
Right. They are.
Because of her inconsistencies. Yes, I understand why it would take longer, but 58 court days. How many weeks?
A long trial.
Yeah, a month is 20 court days tops. My cat is impersonating a parrot at the moment and sitting on my shoulder.
Oh, cute.
Yeah. Let's see. There he is.
Hi, kitty. Oh, that is so cute.
Yeah, he climbs up there, he rests, and then he attacks me. Yeah,
that's like my daughter.
Yeah. 58 days, that's three months of trial. And it's simply not necessary. And I'm so glad that Vielhammer Media also cut out lunches and pauses and breaks and stuff like that.
Right.
Hello, Mr. Jingles.
How long y'all been doing this for? Like 7 months or something, right?
Since May. So yeah, we are going for soon 8 months.
Okay.
Yeah. And we reached day 33. But there are a bunch of days going forward that are only like an hour long. So, yay! As soon as Mr. Jingles jumped up, I saw a spike in viewers. Yeah, this is Mr. Jingles' domains. I'm just here for the ride.
With a simple yes or no.
Well, didn't we just discuss this issue of anal intercourse with the defendant, Mr. Alexander?
Yes.
And you told us that she told you that she'd only had anal intercourse with Mr. Alexander, right?
That's right.
What if it turned out that she had anal intercourse with somebody named Bobby Juarez and Daryl Brewer? Would that be important to you?
Yes, it was.
Would that be important then?
Yes.
So if that turned out to be a fact, would that be then something that you would consider important?
Yes.
Let's assume that's the case in this particular circumstance, that those facts that I just given you are true. Then would that affect your evaluation in this case, and how so?
First of all, the answer is yes. And more information did come out, and she ultimately revealed that she had anal intercourse with 2 other people. But I had written my report by that point.
Judge, well, sir, my question is, you're telling us, oh, I'm throwing up my hands because I've already written my report at that point, right?
No, I didn't say that.
Well, you said you'd already written your report, right?
That's correct. So in my report, it reflects what you told me initially.
Listen carefully to the question. Repeat your question.
You had written your report by the time you learned those facts, right?
Yes.
And sir, one of the things that you also told us was that you wrote an addendum, right?
That's correct.
So nothing stops you from writing an addendum, does it?
No.
And in fact, you did it in this case, right?
Yes.
And if you would have wanted to, and you thought that was important enough to the case, you could have done it with regard to this issue involving the anal intercourse and the other aspects that came to your attention, right?
Yes, but my addendum referred to the new material that
I understand that what your addendum referred to, but isn't it a fact that this material that is being brought to you about the anal intercourse, isn't that new material to you?
Yes.
So you just said to me, well, the only reason I did this addendum was because I had new material, right?
I was asked to comment specifically on the new material.
Sir, you just told us that the reason you wrote the addendum was because there was new material, right?
Yes.
This that we're talking about, this issue, you said, well, it came to me later. And you admitted that that was new material, correct?
I was referring to the material that I listed in my addendum as the material that was reviewed for the addendum.
I understand that, sir. I'm not asking you about that particular addendum. I'm asking you about the new material that came after your first addendum.
So what you're saying then is that you're surprised that I didn't mention.
No,
Okay.
my question is this. You're telling us that there's a procedure that you can employ called an addendum when something new comes to light in a case so that you can have a more complete picture of your opinion, right?
Yes.
In this case, something new came out that you considered important, right?
Yes.
And it involved an inconsistency, right?
Yes.
Yet you chose not to write an addendum, right?
I did write an addendum, but I did not include this new information. That is true.
Well, so you did have this.
Okay, so that was where the prosecution was going. But there are easier way. Why did he have to take 5 spins in the roundabout to get there? He could have just asked him.
I think it's because prosecutors don't realize they can ask leading questions on cross.
Yeah, it might be that. Totally not a Russian bot. How is the body count relevant to the PTSD? It isn't. It is about this witness not being not putting it in his report, even though he thought it was important. And apparently it's not the first thing that he didn't put in his report that he may or may not have found important. So it goes to the credibility of this witness. So it's not her PTSD, it's his evaluation of her.
New information at the time that you wrote this addendum, and you chose to conceal it?
I was writing the addendum specifically on the new written material that was provided to me by the court.
You chose to conceal it or ignore it? What did you do?
I ignored it.
But isn't a person who is conducting a full evaluation on something like this, isn't he duty bound? Aren't you duty bound to at least acknowledge it?
I didn't see it as being relevant to my addendum. Obviously, we're dealing with it here in court.
But it was relevant to your original report, wasn't it?
It was relevant, yes.
And so if it's relevant to your original report and not the addendum, you still feel that there is no need to mention it, right?
It was my judgment call not to include it.
And your judgment call, is it because you had formed some sort of relationship with the defendant such that you were kind of, not giving the full picture because you liked her, or what's going on here?
Objection, Your Honor, argumentative.
Sustained.
You chose not to do it, right?
Could you repeat that?
You chose not to address these inconsistencies in any written form,
The
correct?
focus of my addendum was.
Judge, he's not responding to my question.
He's trying to respond to the question.
Please state your question.
Isn't it-
Listen to the question.
Isn't it true, sir, that you chose not to include these inconsistencies that you've now told us are relevant in any written form?
Yes,
Sir, there are other things that you discussed with the defendant, though, right?
many things.
One of the things that you discussed with the defendant included the issue of the shower and her taking photographs of Mr. Alexander in the shower, right?
Yes,
And according to what she told you, it was actually Mr. Alexander who requested the photographs, right?
yes.
And did you follow up on that by taking a look at an interview between the defendant and Detective Flores where that issue is addressed?
I believe so.
And there is some conversation there about the victim's reluctance to have his picture taken, isn't there?
Objection, Your Honor. Hearsay, maybe approach.
You may.
And a new sidebar. Skip ahead.
Please stand for the jury.
And then morning break.
And
Yep.
she had a new attorney sitting next to her.
Yeah, she's new. I assume. Yeah, I'm not really sure who that is. Let's see if we see a better picture. So it seems to be somebody who walked up to her.
Yeah.
So it might be the lawyer's, what you call it?
Paralegal.
Yeah, thank you. No, not Mr. Nurmi is first chair. Then it's the regular. I don't remember her name. That's second chair. So this must be the paralegal.
Please be seated. The record will show the presence of the jury.
Yeah. Judge Glanville, who is the judge in the Young Thug case, he was 45 minutes late. Then they had a 20-minute morning break, and then they took lunch. That was supposed to be done at 12:30. It is now 1 p.m., and he's still not back. So that is why I don't cover it live, and doing recaps later in the afternoon, because out of the possibly 9 hours, then minus lunch 1 hour, minus 2 breaks, we're down to 7.5 hours, minus other breaks, we're down to 7 hours. Out of 7 hours possible, I think yesterday I got 3.5 hours of trial time in my stream. That's because he was late, the breaks took long, the lunch took long. I mean, it's no wonder this trial will last as long as it will. I've never seen anything like it. Not over here. Here in Sweden, it's punctual. They lock the door on the dot and start the proceedings. If you're not there, you're not there.
Oh, wow.
Yeah. And the judges are there 15, 20 minutes before, just to make sure everything is controlled, that media doesn't take cameras into the courtroom and everything. They're only allowed to take notes. We have no recordings of trials here at all.
My motto during trial is always, well, they can't start without me.
Yeah. Yeah, but I mean, they have, okay, I sat in on a lower court trial not that long ago, and they locked the door and the prosecution weren't there. And judges said, okay, I understand that the prosecution is not here. We will talk about this in chambers. And then we will move on with the next case.
Oh, really?
Yeah, they just, okay.
But did it get dismissed?
No.
Oh.
We don't get those as much here in Sweden.
Oh, okay.
Yeah. But yeah, so I don't know what happened then, but I assume they got a mouthful about being punctual. And here's the thing, we don't do elections here. So prosecutions, if they are deemed, they can be reported to their bar, so to speak. And
Wow.
too many mistakes, and you're out because you're appointed.
Nice.
Yeah. Now that's rare, of course. You can get 10, 12, 20 reports before anything substantial happens, but it will happen sooner or later. Oh, look at that. Tuesdays are our short days. Saturdays is our long days. And it is now
Oh, okay.
1 p.m. And I know that Dave chose to go on with the stream because he was raided by Joe Niemann. And he got a lot of viewers. And I completely understand. I would have done that too.
Yeah.
That you can't miss out on that opportunity with that many viewers.
No.
So he's doing a full days of stream.
Okay.
But yeah, so I will be, I think both me and Dave will redirect to Dave's stream. My stream will start 4:30 US Eastern. That will be 10:30 p.m. Swedish time. And yeah, and then I will go through today's, the Young Thug trial. There are still, now today's witnesses so far has been about a traffic stop. It is so stupid.
Ridiculous.
Yeah, a traffic stop where the third person said, yeah, all of these things are mine. And he's not even indicted. He's not even in this indictment.
Was it the drugs and weapons or something like that?
Yeah, something like that. I just listened to it in the background. And they had 2 cops testifying about it. 2 witnesses
so
about
silly.
the traffic stop. Yeah. And this is after the judge ordered the prosecution to limit the number of witnesses.
Oh, really?
Yeah. But they don't, prosecution doesn't care because they know he won't do anything about it.
Right.
Yeah. Okay. Everybody, thank you for being here. I will send you all off. Thank you to McKinley for being here. Go subscribe to her. Thank you to Mr. Jingles for making a brief visit. And I will see you all later on the Young Thug Rico trial stream. All right. Thank you. Bye-bye. Let's see. Where's my outro? Where's my outro?
I don't know.
There it is. Bye-bye.
The State of Arizona versus Jodi Arias verdict, count 1. We, the jury, duly impaneled and sworn in the above entitled action upon our oaths, do find the defendant as to count 1, first-degree murder.